Welcome, everybody. I'm Michelle Robertson. I tend to never introduce myself, but I'm going to try to introduce myself today. I am a lawyer. I've been a lawyer for, 15 years almost. I've been with Sierra for the last 9 or 10 of them. Sierra's been around since 1993. We only manage properties here in Santa Barbara. So from Carpinteria to Goleta is our regional area. So we're very local. We manage about 1,400 doors, and we staff about 30 people. So if you're not familiar with us, hopefully you'll get to know us. Everybody on my team is wonderful. And I'm here to just kind of talk to everybody about tenant rights and responsibilities, give a little bit of an overview. And you'll note on the presentation that a lot of the words and phrases, I'm giving you what the law is and where you can find the statute. So you have that, but I'm not going to read it to you. I kind of like going through the presentation on showing you what the law is and then telling you an example and a story behind it, because we have so many stories in property management. A lot of them are real life stories, and so that might help you guys understand, like, what are my rights, what does that mean, and how far might it extend in some of these examples. I refer to owners and landlords and property managers. I call them property providers. So if you hear landlord or property provider, it's the same thing. If you hear owner, sometimes they self-manage. I'll refer them as property providers. So that's kind of blanket across the board. Special note regarding voucher holders. There's a lot of rights that are afforded to Section 8 residents, and I'll touch on some of them, but if you have specific questions, they have sometimes more rights than what's in the presentation. I'll take questions at the end of the presentation so that we can have a Q&A, and if you want to write them down and make sure you don't forget them, I'm happy to answer all your questions. We have an interpreter in the back, so I'm going to try to not speak as quickly as I usually do so she can keep up. And I do speak Spanish, and I can answer them in Spanish if that's your preferred language too. So when we get to the end, we'll get there. So this is kind of during the life of the lease, and I want to start before moving in. So you're out there, you're looking for a property. What are your rights and responsibilities when you're searching for a place and looking for a place? And one of the main rights that we have federally, but also California, they add extra rights, is that you're entitled to fair housing. And that just means that a property provider cannot discriminate against you for a lot of protected reasons. And it's codified in so many different areas. So the federal right gives you, this many reasons. And then the California Civil Rights Act and the California Unruh Civil Rights Act, they give you more protected people. So this can be regarding, your color, your race, your gender, all of those things. It's basically, for property providers, none of our business. We are just looking at your application. We're looking to see, were you a good tenant in the past? And can you afford to live in this place? So, and that is protected by law. So if you guys have a problem, there is an office that you guys can go to and make a complaint and say, hey, I think that this person rented to them and not me because I'm a woman, or whatever you felt during that time, you do have a right to complain about that, and they will investigate. So during the qualification process, a good property provider should have what their standards are and should never change them. Because in my office, I always get asked, hey, I know we don't take a guarantor or a co-signer in this building. However, this lady, she seems really nice, and she's retired, and her kids are going to pay for her, and can we have the kids pay for her, and now that's a guarantor? And the answer is always no, because what makes us think that another person who would have somebody else pay for them is different than this little old lady you just happen to like? So there's a lot of biases that we carry with us, and we may not know it. So, that you try to prevent by saying, I need a credit score of this much. I need the person to make this much money, and I need them to have good references. So that's a credit policy, like 600 credit score, this much money, and that is what you have to stick by. So if the property provider is being a little loosey-goosey and you're saying, well, hey, my credit score is only 400, can you make an exception? And they say no, it's because they don't want to violate this, because you might seem like a nice person, but somebody who's not your race, your gender, whatever it is, they might not be as nice to them as you are. And now they're discriminating against somebody else that they wouldn't have made an exception to. They can't charge more than 1 month's rent as a security deposit for an unfurnished unit. So that law just changed last year. It was kind of slowly moving in that direction. That means that when you sign a lease, if your rent is $2,000 a month, your security deposit is also $2,000 a month. There are some exceptions to small property owners if they own less than X amount of houses in the state of California. It's a very rare exception that applies, but but there are some exceptions, so you know that. So if you're renting a house and that's the only house that that person owns, and they say, oh, your security deposit is going to be a little bit more, then they might be under the exception. But it is a rule that it's, generally speaking, for the most part, one security deposit. Now, the law changed to make it 1 month. It used to be 2 months. That doesn't mean that anybody who's on a lease right now is entitled to a refund to the past security. So if you moved in and your rent was $2,000 and you paid $3,000 at move-in, the property provider does not have to give you that extra $1,000 back just because the law changed. It's only to the California, the way they wrote it, what they wanted to do is make sure that because the rents were increasing, they wanted to make it easier for people to get into a unit. And it wasn't covering people in established residencies. So application fees are also big. A lot of people say, look, I'm having a hard time finding a place, and I've applied at this place, this place, this place, this place, and every time I apply, it's charging me $45, an application. But this guy charged me $100 for the application fee because so many people wanted it. Well, under state law, you can't. The property provider can't do that. So there was a law set back in the 80s that said you can only charge $20, I think, per application, and they're allowed to tick up every year based on CPI, and we're at about $45 now. So that's why it says it's approximate, because every year it changes just a little bit. Where we are at Sierra, if we get an application and somebody wants to use that application for a different unit, we do, let them transfer it over to that other unit. A lot of people, I've seen some landlords do this. What they'll do is they'll put a unit out for rent, and they'll have an application that they're qualifying, but then they'll keep taking like a dozen more applications just to get those application fees. It's not good practice. So if you have a complaint about that, just say, hey, that's not right. If you had no intention to rent to me, there should be no reason you're charging me for an application fee. And we can't make any portion of your security deposit non-refundable. So this came up a lot during COVID, where people were renting Airbnbs for a temporary amount, and then they were staying more than 30 days, and then it became an actual tenancy. And then the Airbnb people were like, well, you have a non-refundable $400 cleaning fee. It's not allowed under California law. So the security deposit that you put in, you are allowed to get 100% of it back if you return it in the condition it was given to you, minus wear and tear. So there's nothing in the lease that a property provider, landlord, owner can do that says you're going to pay me X amount of dollars out of your security deposit when you move out for this. And I charge this to everybody. They can't do that. So just be aware of that. So for responsibilities, you guys have to be honest on your application. We have turned down people and denied applicants because they were just simply dishonest on their application. The way our sentiment is, it's part of our application process, is that if they're lying on their application about one thing, what else are they lying about? So if you're submitting, we look at the ID, we're looking at the address there, we're looking at your application. Where did you live before? We call the people, and then sometimes when we're a little suspicious, we will look to see who was the owner of that property and then track them down. And then we find out that the person we called wasn't the landlord at all. It was just a friend. So when that stuff happens, for us, our application process is like, that's dishonest. You're not passing the reference check. So don't lie on the application. Another thing that came up a lot, not so much now, but a few years ago, was people would move in and they would say, I don't have any animals. No, I don't. Great, great, great. Sign a lease that says it's no pets allowed. They will move in, and then they'll move in a cat. And you say, well, you said there was no animals. You have a cat, and now you're breaking the lease immediately when you moved in. Well, that's my ESA. So it's like, okay, but you didn't tell us about that in the application. So now you're immediately starting with the lease violation, and that is not a good way to start a landlord-tenant relationship. So just make sure you're honest, because it could be detrimental to the housing when you get it, and it can be detrimental to even get housing because you might get caught. So during the tenancy, you have the right, they call it the implied warranty of habitability. So this means that somebody can't rent you a shed in the back and say, here, I'm going to rent you the shed and you can live there, because there's no insulation, there's no heat, the roof might leak, and you might say, I want to live in the shed. I don't have a problem with it. But I've seen people draw up leases and say, I'm going to lease you this place, but you're responsible for maintaining all of these things that are habitability. And they're like, it doesn't come with a heater, but you need to provide the heater. Not really. So even if it doesn't say it in your lease that I'm giving you a habitable unit, every lease secretly has the implied warranty saying, when you rent any place in Santa Barbara for living, it should be habitable. You have a right to privacy. I've listed all the reasons that they say, the state says somebody can enter your unit. And I've seen some people some owners that self-manage, and they're like, oh, I just knock on their door and I tell them if I can see the unit. It's not allowed. You're allowed to your right to privacy. And if you didn't have any repairs scheduled, there's no reason for somebody to just say, I'm coming in, because I tell all of our owners, we do third-party management, so we manage for other people. It's like, this might be your house, but it's the tenant's home. So it's whoever's renting that place, it's their home, and a property provider should have to respect that this is your home and tell you when we're going to go in, what we're going to go in for. And these are the only reasons to do it, plus two more. And one of them is that the landlord does have the obligation to maintain your smoke detectors. That doesn't mean that you don't have to change out the batteries if you don't have a 10-year, which are becoming obsolete, but the landlord has to make sure that they're operational. So they can go in, give you a notice and say, this is necessary because I'm responsible for making sure those smoke detectors and the carbon monoxide detector are operational, and give you a notice to enter as an annual inspection to go in there. If your property might go for sale, or a lot of people right now are dealing with insurance companies are wanting to inspect, that's one of those that is allowed to go in. But again, they can't just knock on the door without telling you in advance that they're going in. You're entitled to a 24-hour notice if it's posted on your door. And if they mail you the notice, you have to add at least 5 days to that notice. So most property providers will call you and say, hey, can we do it this time? What works for you? And try to work with you instead of just putting a notice on your door. So your responsibility as a resident is you need to just make sure to, if you do have a notice or you have called for a necessary repair, like you're saying, hey, and this actually happened. This is a true story. Somebody calls 7 in the morning and they say, there is sewage coming out of my bathtub and it's going to start pouring into my unit and I need somebody here, and to clean this up right away. And it's like, great, the plumber's on their way. We're giving them a key, and they're like, actually, you know what? I need to get ready for work right now, so I'm going to be leaving. Can they just come in 2 hours? And that's a no. If it's an emergency, you're calling for an emergency, you got to let the property provider to try to get in there to not damage the property further. So that is a reason for them to go in without notice for emergency reasons. Flooding from upstairs to downstairs, if you're not home, that might be a reason somebody goes into your space to try to resolve that. And if you are given notice, to go in there for maintenance, or you've authorized them, and then you say, no, you can't come in, that can be a lease violation if you were properly noticed. So just kind of be aware of that. If you have good notice for the reasons from the prior page, and you can't say no at that point. There's a new law in the county of Santa Barbara. It's only affecting Isla Vista at this time, where the county is wanting to do inspections of tenant units. So they're telling the landlord, hey, landlord, you got to give the tenant the notice, and you got to show up with the key because we want to inspect these units. And the landlord, it's not one of the listed reasons they can go in to allow the county to go in. So the tenant has the right to say no. So, and that falls, property providers aren't falling under the Constitution. Those are private contracts, but the county is. So the tenants do have the constitutional right to say, hey, I don't want an inspector in my unit. You can, I just don't want it, and just say no. We've been watching them, and what they just kind of come in and say, hey, I'm the inspector, and can you, I'm here to see your unit. They're not asking for permission, but just know that you can actually say, I don't want this. But it's a tenant's choice. So you have the right to reside in your unit the duration of the lease term. So this comes up a lot, especially when there's a lot of sales. People sign a 1-year lease, and in City of Santa Barbara, County, and Goleta, the property provider is required to offer you a minimum of 1-year lease. And then the house goes on the market, or the units go on the market, and the tenants get nervous. They're like, well, am I going to have to move when the new person buys it? What am I going to do? And if you have a signed contract with the existing owner, that contract carries over to the new owner. So that means that if you sign 2 years, and that's what, that's how long you were allowed to stay there. So a lot of new owners, the investors come to me, they're like, well, what am I supposed to do? I'm trying to buy this place, and they're under market, and I need to do all this stuff, and I wanted to move in. And it's like, you know what? They have a 2-year contract. You can negotiate with the tenant and say, I will pay you to get out and move, and this is what I want to do. But the tenant can just as easily say, absolutely not. This is my home. I don't want to move. My kids are in school, and I have a lease. So you have every right to say no. You don't have to feel pressured to allow the property provider to tell you, like, you need to sign this. And I've seen that happen. Just say no if that's not what you want to do. One of the things I do mention is, if you violate the lease term, a lot of owners are kind of loosey-goosey on, like, all right, you brought in a dog, we'll let it go this time. But if somebody wants you out, they're going to be looking for you to violate the lease terms. So just make sure you're compliant with everything on the lease, so that you don't give anybody an excuse to kind of try to push you out. For month-to-month tenants, and even, so when you're on a lease, you have all the rights to stay there. A lot of people are like, I'm on month-to-month. Does that mean that they can kick me out with a 60-day notice? The answer is sometimes. And it's also an exception. So this is most of the rule for everybody. But the exception to the rule is single-family homes are exempt from this law. So it's not blanket across the board. So condos, single-family homes, units that are 15 years or younger. But for most properties in Santa Barbara that are multi-units, they cannot just give you a 60-day notice to move out. They have to have any one of these reasons and tell you that this is one of the reasons. So the common one that comes up around here that's been a big thing is the rent eviction. People talk about the rent eviction. Oh my gosh, I'm getting rent evicted. And that's when the property provider wants to substantially demolish or renovate the unit. So that doesn't mean they just need to do flooring and paint. That means that they're going to change walls around, and they cannot do it while you're in there within 30 days. So they have to not only give you notice, at least in the city of Santa Barbara, they have to attach the permits, tell you why they can't do it within 30 days, have somebody sign off that they can't do it within 30 days with you living there. And they have to offer you to come back to that unit once it's renovated within 2 years at a similar cost that you were paying before you got told to move out. So the other one that that comes up not as often are the first two. When an owner, wants to live in one of the units, and it has to be them that's living there, and they have to be living there. They can't just move in for a month and then be like, okay, I lived here for a month and now I'm going to move out and rent it to somebody else. They have to live there for a few years in order for a relative, so the first one, to kick in to evict you so they can move in. And it has to be on your lease. And then the other one is if it's been withdrawn from the rental market. So I've seen this a lot, and I haven't seen it a lot, but I have seen it happen. Investors will buy something in city of Santa Barbara. It's usually only on the coastal zones, very limited areas. But they'll buy something and then they'll give notice to the tenant and they'll say, well, it's because I'm withdrawing it from the rental market. And what they're doing is they're converting it to an Airbnb. And then the tenant says, well, wait a minute. You're still renting the place. You're just renting it by the day or renting it by the week. Like that's not taking it off the rental market. The California laws distinguish between long-term residential rentals and short-term rentals. Short-term rentals are more akin to hotel rooms. So that's why they have to pay different occupancy taxes. And so they do consider an Airbnb conversion taking it off the market. So no fault terminations, you should know why if it's a substantial remodel. You're also entitled to relocation benefits, and it differs depending on where you are between Carpinteria and county. So it's different in county, it's different than the city of Santa Barbara, it's different in the city of Santa Barbara than the city of Goleta, and it's different in the city of Goleta than it is Carpinteria. So all of them have different relocation benefits. And the right to return that we just recently talked about, if you get rent evicted, you do have a right to return. Rent raises. So all of California, state of California, they are the property provider, again, with the limited exemptions of the single family home. They're capped at how much they can raise your rent every year. And the cap is 5% plus CPI. And the CPI number that is used every year is from April. And we generally know in June what that number was. This year, until around June, when the number changes, the total amount is 7.7. So CPI was 2.7%. So 5 plus 2.7 is 7.7. So your rent cannot raise more than that amount every year. What was that amount? 7.7. These are the tenancies that are exempt from the law. And I find it really interesting, but basically if it's on one parcel and there's one house, that's exempt from the law. So condos, they have one, they call it an APN number. Condos are exempt from the law. We manage a property that is several acres, and they have several properties, miles apart from each other. It's up in the hills. But because it's on a single parcel, they are not exempt from the law, even though they're all single family homes within one APN number, because they cannot be sold without doing a lot line split. And a lot of mom and pop owners get into trouble with us because they think, okay, I have a single family home, I'm exempt from the law, I can raise my rent as much as I can, I don't have to tell them why they have to move out. All those things are true when you're exempt if it's in your lease. This property is exempt from the law. Or they sent you notice in 2020 because you're a long-term tenant. If it's not, then it's not exempt from the law anymore. So even though it meets all the criteria to be exempt, brand new unit just built, if they didn't put it in the lease that it was exempt, it's not exempt. So you would be entitled to the relocation benefits, you're entitled to the rent cap. So anytime those issues come up, look at your lease and be like, did they put it in my lease? Did they tell me it was exempt? And you'll know whether or not you're exempt, even if you're in a single family. So tenant responsibilities, this is kind of what I kind of touched on earlier. If a landlord doesn't want to be gracious, they're going to look for reasons to terminate your tenancy. So we get a lot of people that, especially with the USPS and the theft of checks, and we had a lot of people that said, hey, my account was compromised and I had to close it and they won't release my money and I can't open a new bank account and I can't pay my rent on time, or my check bounced because of that, because it was compromised. Can I have another 10 days? Most people will say yes. Of course, like that's a horrible situation. I was in the hospital, can I have another few days? Of course. But it doesn't mean that the landlord cannot still issue you a 3-day notice to pay or quit and start that process. So just kind of be wary of that. Maintain good relationships, because most property providers that I know are willing to work with you, because they don't want, I tell people that people look at landlords thinking, oh, we just want to evict everybody and start over, and it's absolutely not true. We're in the business of housing people, not unhousing them. And anytime we have a vacancy, it's like money lost for the owner, and it's a lot of work trying to find a new tenant to get in that unit. There is maintenance issues. So I wrote down, like, don't commit waste. I had a tenant just last week. She's like, hey, I understand that landscaping is not provided in my lease, so I don't get a gardener. However, that doesn't mean that I have to do the gardening. And it's like, well, you were giving this property and it was really well maintained, and if you find it in disrepair, then the owner's going to have to put it back the way it was, and you're committing waste. And so you kind of do have a responsibility to at least maintain how it was provided to you if it's not provided to you in the lease, and not let it go into disrepair. If you have a leaky roof, a lot of people are like, I'm not going to report it. It's not a problem. I'm just going to put a bucket. But that leaky roof can lead to mold and rot in the rafters, and all of a sudden the owner has a $30,000 job that they could have had a $400 job, repair to do. So you have a duty to tell the owner when something's wrong. A lot of people say, oh my gosh, I just don't want to bother them because I don't want my rents to go up, and it's going to be worse if you don't tell them. So the most common question I get from tenants is, I don't want to call my landlord because they're just going to charge me for the repair. And it's this distinction of, what can the landlord charge me for, and what should they charge me for? So a lot of times it's listed in the lease, but generally speaking, if there would not have been an issue had you not caused it as a tenant, then you are not responsible, or you are responsible for the repair. So we see shot glasses in garbage disposals. Plumber goes out, tenant's like, oh, my garbage disposal doesn't work, it's jammed, and plumber goes out, he goes in and finds a shot glass. It's like, there's a shot glass in there, and now I have glass and I have to repair it, and the visit was $85. And it's like, okay, that is a charge to the tenant, because if that shot glass would have never gone down the sink, the plumber would have never gone to try to get it out, and it would have never jammed. But if your garbage disposal, you turn it on and you reset it and it just doesn't run, and the plumber goes out there, is like, oh, the garbage disposal died, that should not be a tenant charge, because there was nothing that you did that caused that garbage disposal to break. It just happened to break because it was, out of life at that point. So comply with the lease terms. Don't sublet. Don't cause disturbances. Comply with the laws. Some people think that they have a free pass to just annoy their neighbor. They don't like them. They don't like the way they look at them. They're just going to start yelling at them every time they walk by. You're probably violating a lease term, because everybody has the right of quiet enjoyment in their unit. They have the right to live in peace. And most leases say that if you're causing a nuisance and disrupting somebody else's right to that quiet enjoyment, then you're violating the lease terms and you can get removed from that property. So don't do that. In anticipation of moving. So you decide, okay, I found this great place, or you applied for the affordable housing after the next seminar and they got you an affordable housing unit and you need to move out. So you need to let them know that you're moving out. And usually on a month-to-month, it's a 30-day notice. So when you're on month-to-month, they call it creating a new tenancy, because you're paying every month, and that created the new monthly tenancy. If you're on a lease and you signed a 1 year and it doesn't end until July, you might be responsible for the rest of that term. And the landlord can't sit there and say, well, nice for you to find affordable housing, but guess what? You're on a lease until July, so it's just going to sit there and you have to pay for the rent. So it's up to you what you're going to do. They can't do that either. So the landlord has what they call a duty to mitigate your damages, and that's the fancy legal term that says that they have to try to at least rent that unit for you, so that you're not just paying them. They can't just sit there back and be like, you signed the contract, not my problem. They actually do have the obligation to go through and try to get that unit rented for you if you want to move out of there so that you're not out of rent. What we tell our tenants in that scenario is it's likely easier for a tenant to find a replacement and work with that person, because then they can plan their move out date quicker. They can say, like, I'm going to move out on the 3rd, if you can move in on the 4th, and make it seamless. But if we get possession of a unit and it's vacant and we start over, we have to put it on the market, and it's harder for us to get somebody in there as quickly as possible, because we get the tenants that are just like looking around and wondering, do I want this one or do I want the other vacant one? And they shop more with us. So if that's something that you want to break your lease, just keep in mind that it might be better for you to try to market it. Ask the property provider, like, do they send the application to you? How do I do this so that you make sure you have a smooth transition? The notices that we kind of talked about, how a no fault termination can happen. You're entitled to days of notice, so they can't just say, like, you got to be out in 15 days. That cannot happen. They can't do that. So even for the rent evictions, they have to give you an early alert notice of 60 days, and then they can give you a 60-day notice. So you have a minimum of 120 days before you have to move, at least in the city of Santa Barbara. Some of them are 60-day notices, 90-day notices for Section 8 housing, and they also have their own cause as to why you can terminate those tenancies, a little bit different than the state laws. And 30-day notices, very limited reasons. If you were there living there for under a year and you waived your right to the 1-year lease and you're on month to month, then the owner can give you a 30-day notice. But if you've been there for more than a year, it's generally 60 days minimum. The 30-day notice that you have to give to your property provider is a little bit different depending on your lease. Some owners, and I've had some of our owners tell me, like, I said, hey, this person wrote to us on the 15th and they're giving us 30 days and they're going to move out on the 15th. The owner's response is like, well, you know what? They should have given it to us on the 1st, because that's when the tenancy expires and that's when the notice should have been given. So they actually should be responsible until the end of the following month, and that's 45 days notice. And technically that owner's right. But we don't follow that rule. Just be aware that some owners might say, like, month to month means 1st to the 1st, and I need you to give notice on the 1st. But most people don't follow that rule. So it can go either direction. The initial inspection. So earlier I had talked about that a tenant has the right to get their 100% of their security deposit back. When you give notice to your property provider, they have to give you the right to an initial inspection. And if you accept it, a lot of people don't. I would say that 90% of tenants don't want to do an initial inspection. They have this idea that they get a move-out inspection. They're like, well, great, I just gave you my keys. Can you come inspect it now and give me my security deposit? I'm like, kind of doesn't work that way. The idea of the move-out inspection is the state of California said, hey, the tenants should have an opportunity to have this unit put back exactly how it was given to them and repair anything that might be broken. And the landlord should tell them what they might charge them for so that they can fix it before they move. So that's why your inspection can't be more than 14 days before your move out date. So if you said you're moving out on the 15th, then your offer should be 14 days before the 15th, and you should accept it. You should say, yeah, you know what? I'd like you to come over. A lot of people say, no, I'm moving. I have boxes everywhere and I'm just not ready. I don't want you in my house with all this mess. Just accept it. When I walk in a unit, I don't see anything but the unit. Like, I'm not looking at boxes. I'm not looking at bowls on the counter. I'm not looking at any of that. I have 2 kids and I know how life gets. I tell people when they come over my house, I'm like, sorry for the mess. I live here. Like, this is just, we live there, like, this is not what we're looking at. We're just looking for damage and telling you how you can remedy it so that you can get 100% of your security deposit back. The biggest charges are cleaning fees. So a lot of people say, well, I clean, and you're charging me anyway. What happened? And the cleaners that do move out clean are very specialized. So for us, they take down all the fixtures, they wash the fixtures, they pop out the windows and wash them inside and out. And they pull out the stove, wipe behind the stove, so that when somebody moves in, we know they're in a clean unit. And if you came and you just mopped around and wiped down things, we're going to look at it and be like, this is not clean and we can't move somebody in here. So we're going to pay somebody to clean it again. So just keep that in mind. We are happy to give our cleaners phone numbers that we use to our tenants if they want to negotiate directly with that vendor in advance and say, hey, how much would you charge me, so that they know it's not us that is charging them that fee. It's actually a company that we're hiring that is charging what the cleaning fees are and what they do. So property provider is required to tell you that you're entitled to an inspection. You have the requirement to accept the inspection, otherwise it may not happen. And then giving possession. A lot of people say, well, I'm just going to leave my keys on the counter and not tell anybody because they know I was going to move tomorrow. And a property provider can't go into your unit without the listed reasons. So unless you tell them, I am completely out and you can find the keys here, we can't go in. And that means that, we've had people move across state and we're waiting for the keys. We're waiting for an email like, hey, tell us, did you move? Did you move? What happened? And we're calling them. They're not answering because they're traveling. And 2 weeks later, they'll call us to be like, why didn't you go in? And we're like, we couldn't. You didn't give us possession. And now we posted notice on your door that we thought you abandoned the place, but that means we have to wait another 16 days before we can enter the unit, which means we're losing rents because we can't do anything because you didn't give us possession. So the symbolic gesture is by giving the keys. It's like you loan somebody a book and they give you back the book. You can't give back an apartment, but you can return the keys. And that's just a symbolic way of saying, here, thank you. This is yours now and you can come in. So don't forget to do that, because you can be incurring charges of the daily rate if you don't turn in your keys or give possession back. So after moving out, your security deposit, you have the right to an accounting of your security deposit within 21 days of move out. And that includes dollar per dollar, everything that they charged you for, there should be an invoice attached to that. So you're entitled to all the invoices that were paid. And you can call all the vendors to, I have a story. I have my little brother. He moved out of a place and he got charged $4,000 out of his security deposit. And he was only living there for 2 years. And he's like, hey, what happened here? They're like, oh, the place was a mess. He's like, no, it wasn't. And the guy couldn't show it. So my little brother calls the vendor that was listed on one of the receipts. And the vendor's like, I have never been to that place. So that happens. You are welcome to call the vendor and make sure that the work was done. But the state of California did pass a new law that says you're also entitled to photos of before and after work. So right when you move, somebody should be taking condition pictures of your place. And then when they're turning in your invoices and the receipts, you should also get pictures of, look at how it looks like after we repaired the wall, the hole in the wall, and we had the flooring repaired, and show you that we actually did the work. So you're entitled to that now, but that didn't come into effect until April of this year. And don't leave anything behind. The property provider, if they're following all the rules, they have to give you a notice that says, hey, you left your couch behind. Can I dispose of it? And they have to wait 17 days until they dispose of that couch. And a lot of them, they can charge you storage fees for that period. So unless you tell them like, hey, haul it off, I don't want it, they'll just charge you for the haul off fee. But if you don't do that, you might get charged for 14 days of storage of something that you never even wanted to keep. So just be aware to just take everything with you and don't leave it behind. Marburg changed their rules in City of Santa Barbara where a tenant can call for a large item pickup. So if you're moving, you should call Marburg and say, hey, I'm planning to move on this date. I'm going to have a lot of trash. Can you do a large item pickup and just, I'll put it all on the curb, and they'll allow you to do that even if you don't pay for trash at your unit. So that's been really helpful for tenants, except that tenants don't know that that's what they do. So they'll call us sometimes after they move out, and then we're like, okay, well, now we got to call them, and and they're not going to come for another week, and then we have to hire our people to do it, and that's a fee versus Marburg doing it for free. This is kind of, it's relevant, but it's not relevant. So I kept it in here because when COVID happened, a lot of people, if you owed money during COVID and your property provider gave you the right notice, they can't evict you for those rents of COVID rents. So you might be thinking like, oh my gosh, I owed $5,000 during COVID and I'm still paying my landlord $100 a month because I don't want to get evicted. And that's really not how it works. It basically is like, no, you can never get evicted for those COVID rental payments. And the other small change that happened is that the landlord can take you to small claims court for the rents due, and it's not capped at whatever the small claims amount is. So if you owed $40,000 in COVID rent or rents, any rents, they can take that to small claims court, and small claims can handle that. So they no longer have to go to a lawyer and try to file it in a big court. They can just go to small claims and just file a little form. So just kind of be aware of how that COVID rent impacted judgments and rentals. But you cannot be evicted for COVID rent if it, until that they can't collect on it until you move out. So all of that said, I'm ready to take on any questions.
There was something you mentioned about, like, for instance, if an owner if an owner's going to sell the place, you have a year-to-year contract with them. And let's say they sell it before that year is up. Now, when the new owner comes in, am I still going to be able to pay them the same rent that I'm paying now?
Yes. So I'm going to repeat your question just because I don't know if it picks up on the audio and the video. And the question is if you're on a year-to-year lease and it's not over yet and the property sells and the new owner comes in, does that new owner have to honor my existing rental rate from the original year's lease? So it's not about the term, because we understand the term. It's about the rental rate, and are they stuck with that number with the rent cap in place? And yes, they are. So they can't just ignore that ever happened and be like, well, I'm the owner now, so sucks to be you. No, they actually have to honor the rate that you've been living in.
And then another question I had was, if you're renting from a senior place, and let's say your light bulb goes up, are you responsible to pay for that, or should they? Because that's kind of like an upkeep with the fire alarm or the carbon dioxide. They come and they replace batteries and stuff like that. So
it depends. A lot of it's lease to lease. Most leases, what they say is that the tenant is responsible for anything consumable in the unit. So a light bulb would be a consumable item. It only lasts a certain amount of time, and only the tenant is using it. So they should be responsible for paying for that light bulb and the replacement of it. So we tell people, like, we can send somebody to change that light bulb for you, but we're going to have to charge for that person's time to do it. So just thinking of it as a consumable, but if the whole light fixture goes out, like that bulb burns because the whole can doesn't work, that is a maintenance item. That's like, you know what, tenant had nothing to do with the can just no longer working. So landlord would be responsible for that. Correct. So a lot of the filters would be tenant responsibility. The batteries the landlords are responsible for making sure they're maintained. Tenants usually responsible for changing the batteries. So, but if the smoke detector breaks, like it's just not operable anymore, then that's landlord's responsibility to replace that as a maintenance item. Yes. Oh, that's okay.
When it comes to the cap to rent raises, you said that one of the exceptions is new housing under 15 years old.
Yes.
So they don't have to go. They can raise the rent above that 7.7%.
Yes. So I'll repeat the question. It's regard to new housing, and if the exception is what happens with new properties that are 15 years or younger. And, are they not responsible for abiding with the rent cap? And that's correct. They can raise that rent as much as they want in that new housing. The rationale behind it everything ends up being politics. And the rationale behind it is that I don't know if you can hear me. I'll pause for a second. When they created the law, the politicians all get together and they all fight about, what it should say, what it should not say, and what they wanted to do is encourage people to build more housing, and that's why they've exempted housing that's 15 years or younger, because they're like, oh, if you do this, then maybe nobody's going to want to build, and so that's when they added, like, okay, new housing, they're exempt from the law, so that the landlord can recoup their costs and not be under the pressure of the rent cap. And the reality is that new housing is usually charged more at the inception, and I don't think the market could bear a higher increase, but that was the rationale behind it. I'll get her, and then I'll take another one from you.
I live in, I have the Section 8,
Mm-hmm.
and I live in my apartment for 15 years. And that is true. When the people pay rent legally 3 days, I need to pay 6% late.
So to kind of recap the scenario, she's in current Section 8 housing. She's been there for 15 years, and she's wondering if she's responsible for actually paying 6% if her rent is late every month. That is contractual, and it depends on what your lease says.
My contract only says $8.
Right, so then you could push back. You could say, you know what, my contract doesn't say I have a late fee, and I don't know why you're charging me 6%, so I don't think I should pay it, because it doesn't say anywhere here that I need to pay 6% based on the lease that I'm in. So I would read those terms and explain, why. And I'll come back to you, Beth. Mm-hmm.
Is it true that for state-owned properties, for example, UCSB
Mm-hmm.
owns housing, that there are exempt from the city ordinances?
Some of them, yes. There is an exemption provision for dormitories. So I would think that a lot of them would classify as a dorm, that UCSB owned housing.
But this one isn't a dorm.
Yeah, and
It's for faculty housing.
Oh, faculty housing?
Yes.
That I don't think so, because let me see if I have the definition here. Let's see. Habitable, let's see. Here. University-owned dormitories. So without going back and reading every single ordinance again, most of the ordinances in the city and the county and Goleta, they mirror this language that's in the state when they pass their ordinances. They say, okay, these are the places that are exempt, and they just kind of copy paste what the state says in their own ordinance. But sometimes they get creative. Sometimes they're like, the university may have called and be like, hey, by the way, can you exempt the university-owned housing too? They might, I don't know, but usually it's copy paste from here. So I would look at the city ordinance and see if they're exempt.
No, I mean, their attorney pushed back that, and the reason for that is because it's a state entity. And there were complaints from tenants that they were not offering an annual renewal.
Right.
They were just putting everyone on month to month. And that was the reason. It's like we are a state entity and that we are exempt from that.
Huh, that's interesting. I guess I don't know enough about that to be able to know one way or another how they would be exempt from a state law that does housing. Like, yeah, it's a good question.
I also heard that if you like pay to have a deposit and then through the years, like we've been living, we pay like I think like $2,000 and we've been living there for like 15 years, and that we're gonna you could make your interest will make some interest actually on that amount that you would deposit or was that you had given to
Right. So the question is, can somebody earn interest on the original security deposit that was deposited, especially if you're residing somewhere for 15 years, you should be able to get compounded interest on that security deposit. California does not have that rule. I know that the state of New Jersey does, just because I practiced there for a few years, but the state of California does not have that rule. There has been talk that they want to impose that rule. They've also been talking about maybe allowing tenants to use an insurance coverage instead to pay the security deposit, so that you're not paying the security deposit, you're paying for an insurance who will, cover the security deposit if there's damage. But that's not in the books yet. But I wouldn't be surprised if it would be soon. ¿Una pregunta atrás?
Tengo sección 8 y vivo en un departamento. He cumplido un año de renta. Quería saber si tengo que necesitar permiso de housing para poder moverme porque el lugar es muy frío. Me dio neumonía y llegar al hospital. El mantenimiento de la calefacción es muy caro. Porque todo es eléctrico. Quería saber si hay excepciones en el caso de.
Okay. So her question is, she has Section 8 housing, or she's on Section 8. She's been there for a year. She wants to know if she's allowed to move to another residence because it's too expensive for her to operate the heating because it's electric, and the electric is just too much to pay every month. So it's not that she doesn't have heating. It's just that, it's just too expensive to run it. And yo no sé si la pregunta es para Sección 8, si ellos te van a dejar mover de un departamento a otro departamento. Yo creo que tienen algo que se llama porting, si es en otro lugar, y transferir el voucher, o si la pregunta es que si la persona ¿quién es el dueño de tu habitación? ¿Es Sección 8 también? Ok. Ellos sí te van a dejar mudar si quieres mudarte, pero la pregunta va a ser para tu caseworker y a ver cómo te va a dejar mudarse, porque Meridian Group te tiene que ofrecer otro año y puedes decir, no, no quiero el año, quiero mudarme, pero la caseworker o el caseworker de sección 8 va a tener que hablar contigo y a ver cómo pueden transferir tu voucher a otro lugar.
Yo consulté con Housing y me dijeron de que por el momento no están permitiendo mudarse. Quería saber si esto es temporal o puede haber excepciones. Pues es imposible vivir con permiso. Peter, aún así siento falta.
See, so the response is that there's two different questions that as I understand it, is she's renting from a third party. She's been there for at least a year. She wants to know if she can move. With the third party landlord, she can move as long as she's not accepting another year lease offer that they're supposed to give her. But the question is, will housing let her move, and can she transfer her voucher? And that's a question for the caseworker. And she's explaining that the caseworker did tell her that housing has a pause on allowing people to move right now. Unfortunately, I don't know the ins and outs of housing. Yo no sé cómo trabaja housing y cómo la burocracia trabaja ahorita y qué van a dejar hacer y qué no van a dejar hacer. Eso es algo que es más departamental, que es ley de California. Y,
conversar con ellos.
sí. Mm-hmm. Yeah, so she'll have to talk to Housing Authority to see what their answer is.
You don't even know housing or anybody's taking applications right now.
I think that the affordable.
There was a hold on, that's what people have been saying, that there was a hold on it. So I was kind of questioning that.
Right, and we have an answer in the back.
Yeah, I can answer that. So our voucher program, which is what the Section 8 voucher that you can take from private landlord, that's currently not accepting applications for moving at this time. I am actually going to do the next presentation on applying for affordable housing because we do have what's called project based and senior housing as well who are formerly homeless. It's a little different because it's not a voucher that's given to you that you can then transfer and look for a private landlord. It's properties that we own and manage. It is open, it's just not what most people think of when they think of vouchers. So the voucher program is closed. We do have affordable housing available currently for other things. And if you guys are interested in staying, I'm gonna walk you through the application process.
Wonderful. Any final thoughts, questions?
Yes.
Oh, one more question.
There, with same landlord, I believe this, we had a problem with the stove, like, I don't know, like 45 years ago, so I think we were living in that place like 10 years. And the stove stopped working, and then she bought a new one, but instead we had to pay like half of it. I wonder if that's legal.
Hmm.
Because I
There-
think it's wear and tear of the stove.
Right. There are some leases. We don't do it, but I have seen some owners, and especially in LA, what they've done is that we don't provide a stove, but we will let you rent one for $30 a month, and you're responsible for the maintenance of the stove. So I would look through your lease and see if your stove is included as part of your unit, in which case owner has to repair. With a lot of washer and dryers, for example, a common term in our lease for washer and dryers is, we're going to give you a washer and dryer and it works right now, but owner doesn't want to repair it. They're like, we don't want to repair it. Like we just moved and just wanted to leave it there. So we were like, owner's not responsible for repairing it. So if it breaks down, tenant is responsible for repairing. So if you have to look at your lease to see if that's language regarding the stove, as to whether it's owner's responsibility or tenant's responsibility to fix and replace.
But the laundry is coming with my contract, and she's putting the new one and don't give it to another apartment, only for the new ones. And it's legal.
Is it a common area laundry room?
It used to be, but I think somebody broke into it and they were like stealing the money, and then she bought new machines. She installed them and she opened it, but she only gave the key to one of the other tenants.
Okay. So the question is generally, when I moved in, I had a service that was included in my lease. And now she's just taken away that service, the washer and dryer, and now it's no longer included in my lease. A lot of lawyers, how they'll treat that is as a rental reduction, like you're no longer getting what you bargained for, and it should be either one, it should be required, and it can be argued both ways, or two, she shouldn't be allowed to raise your rent if they're taking away something like a parking space. You put a value to it and be like, well, that parking space was worth $100 a month. You can't just take it away from me. So then the question is, what is the value of a laundry room service that was included as part of your lease, and was that part of your lease?
My question is here is discrimination because she's giving to key for the new ones tenant, and another order don't give it to the key.
Right. So discrimination would be, it's because of my age, it's because of, I don't speak the language. But in here, she's discriminating based on probably what people are paying for rent, because the newer tenants are probably paying more than a 15-year tenant. I don't know, but you do have a legitimate loss of service that was part of your rental agreement in the past, and that's probably your better argument. Well, thank you guys very much for having me today.